Well, thank you very much indeed, everyone, for joining us this morning. Just by way of introductions, my name is Martin Priestley. I'm a commercial partner in the Leeds office at Mills Reeve. I'm joined this morning by my partners, Jayne Hussey, who is a commercial specialist and partner in our commercial team also, and by Simon Pedley, who's a litigator and specialist partner based in our Manchester office. Just by way of housekeeping, and on the slide you'll see, and just to mention to everyone, we will be recording this session, and a recording will be available on our Mills Reeve website shortly after the session if you'd like to catch up on any points in particular afterwards. In terms of questions, please do ask us questions as we go in the Q&A box. We will answer as many questions as we possibly can. If you would like to submit questions anonymously, please do so. Alternatively, if you identify yourselves, we will pick up with you afterwards if we don't manage to get to your question this morning. And final piece of housekeeping, if you could, at the end of the session, just give us any feedback at all about how we've done today, about the topics, and about any suggestions you've got for future topics, that would be really, really helpful. And in particular, if you could just let us know your thoughts on, for the future, post-lockdown, would you like to carry on in webinar format for our future briefings, or would you prefer to get back to face-to-face? In terms of an agenda this morning, it's very, so we have a packed session for you today. So we are looking at commonly used but very important contractual clauses, and I think there is also a bit of doctrine coming in as well around frustration. So I will, if I may now, hand over to Simon, who's going to start our session by looking at force majeure. Thank you.
Fantastic. Thank you very much, Martin. Good morning, everyone. As Martin teed up, just at the start, not only am I talking about force majeure clauses, I'm going to mention frustration briefly. As the perspicacious among you will realise, why am I talking about that? This isn't a contractual clause. I'm only going to mention it briefly because that effectively sets the groundwork for if the proverbial hits the fan in your contract and you've got nothing in your contract about what happens, something like frustration may be your only remedy. And we'll just see very briefly why that's a very blunt tool and not a very effective one. So if we can go to the next slide, please, Kate. Just very briefly then, what is frustration? Well, it's a common law doctrine, and a frustrating event in a contract is, generally speaking, one which occurs after the contract's been formed. It is so fundamental that it strikes at the root of the contract, or it's completely beyond what was contemplated by the parties when they entered the contract. It's not due to either party's fault, and it renders further performance illegal or impossible, or makes it so radically different to what was contemplated that the contract can't proceed. And as you'll know, the sorts of things that do amount to frustrating events are things like destruction by fire of the subject matter. So if I have a Picasso, a unique item, I agree to sell it to you and it's burnt, well, the contract simply cannot be performed in any way, shape or form. So that would be frustrated. But conversely, if I say a contract to sell you my headset and that gets destroyed in fire, well, the contract isn't frustrated because I can source another headset from elsewhere, even if it becomes expensive. So that's the sort of thing that frustrates a contract. The sorts of things that don't frustrate a contract would be where the parties have made provision for the event in question, where the parties should have foreseen the event, where another method of performance is impossible. It's not frustrated just because it's more expensive to perform. And that's the sort of issue we looked at with quite a lot of clients when the pandemic first hit around force majeure and frustration. Are we still obliged to do this because it just doesn't make any commercial sense now? Well, generally speaking, yes, you are. And one of the main cases on the subject was where I think the Suez Canal was shut at one point, and this particular delivery of goods, which now had to go via the south end of Africa, suddenly became an uneconomic contract for the party performing it, but the contract was held not to be frustrated. You could still perform it, just more expensive, and that's tough for you. So that just very, very, very quickly is the sort of stuff that is or isn't frustrating. The consequences where a contract is frustrating, generally speaking, at common law, that's it. The contract is over from that point on. Losses fall where they lie. If you have spent a lot of money performing the contract but haven't got the other party hasn't been obliged to pay yet, and it's contracted and the contract comes to an end, you don't get paid. Conversely, if you've paid a large chunk of deposit but haven't got the benefit of the contract, you would have to bear those losses unless there's been a total failure of consideration. But if the contract's been partly performed, losses fall where they lie. There is an act called the Law Reform Frustrated Contracts Act, which applies to most commercial contracts, and that has got some more provisions around recompense and where losses lie, and is a bit better. But again, it's a very blunt tool. And so if you don't provide for a disastrous event in your contract, and you may be having to rely on frustration, which is very difficult to rely on, and even if the contract is frustrated, that may lead to a very unfair result for one or both contracting parties and may well not be what you want. So the solution to that is you draft something in your contract. And then we come on to force majeure clauses, which is the main point of this. So Kate, if you could take us to the next slide, please. So force majeure, what does it mean? Well, literally it means superior force. And what is the concept of force majeure in English law? Well, this is a nice, easy one. There is no concept of force majeure in English law. It's not defined in statute anywhere. It's not a common law doctrine. It is absolutely meaningless. It is purely a creature of contract. If the parties provide in their contract for what happens when a supervening event occurs, that clause is called a force majeure clause. But force majeure itself has no meaning in English law as compared, say, to the civil code in France, where there is a statutory meaning of force majeure. So it's all about the drafting. So if we go on to the next clause, the next slide, we've got an example clause there. I'm not saying this is a good clause. I'm not endorsing it in any way, shape or form, but it's an example of the sort of thing that we're used to. And I'm not going to read it out in detail, but as you know, you tend to get a shopping list of sort of different types of disastrous events. And as with this one, you tend to have general words at the start. So here it's acts beyond the party's reasonable control, including without limitation. And then these list of other things. And the one that sort of particularly exercised people a year ago today, pretty much as we headed into lockdown, was what about pandemics? What does that mean? So that's the sort of clause we're looking at. So what if the relevant type of event occurs? What do you do? Well, if we can go on to the next slide, and something has happened, whether it's a pandemic or a fire or whatever it is, and you're considering is a force majeure clause effective? Is it triggered? Firstly, you've got to look at the particular event. Does that fall within the definition within the clause? So if it's a pandemic, is pandemic included? Or if it's pandemic is not specifically included, is there some other wider description that would include it? Or if a fire's there, is the fire included? That sort of thing. So first thing, does the clause even cover the event you're looking at? And secondly, you then look at what does the clause say about the link between that and what the party, the effect on the party. Some clauses say the clause will only kick in if a party is prevented from performing its obligations under the contract due to the event, which can be quite a high threshold. Some others say it kicks in if a party is hindered or delayed from performing its obligations, which is, as you can see, a lower threshold. And that's quite an important one, because if you have to show that you have been prevented from performing your obligations because of an event, that might be quite tricky to do, whereas showing you've been hindered or it's supposed to be made more difficult, that's generally going to be a bit easier. And these clauses may often say a party has to use reasonable attempts to perform the contract before it can rely on the clause. That sort of stuff will often be in there. So if your event is covered and if you are prevented or hindered or whatever the clause says from performing your obligation, well, then what happens? What are the consequences? Does the clause simply suspend one party's or both parties' obligations for the period in question? or does it terminate the contract completely going forwards? And this was an issue we found with a number of clients a year ago. Even though some of them had force majeure clauses, and even though they covered pandemics, when they actually came to look at them, the consequences that were provided for were completely inappropriate, not what they wanted, didn't suit them at all. I mean, I spoke to one head of legal for a very well-known charity, basically a theatre and arts organisation in London. And when the pandemic hit, the theatres had to close. They had to stop all the productions, all the pre-production work had to stop. You know, musicians, singers, backstage, everyone, these contracts had to be terminated. And the lawyer thought, oh, we've got these force majeure clauses, but in fact, they didn't cover what they wanted to happen at all. So it is very important when you draft them that for each contract or for each similar type of contract, you understand what the consequences are and that it does actually cover what you want. And so sometimes these clauses will provide, well, your obligations are suspended, and then if the force majeure event carries on for a particular period, then the contract can be terminated, and then it deals with where the losses fall and that sort of stuff. Generally speaking, the clauses don't unwind whatever's happened before, so debts that fell due before the force majeure event would still be payable and so on, but you need to think about these things. So if we go on to the next slide, just a few tips if you're drafting them. I've covered some already. You'll have different considerations if you are, for example, the customer, the person who's expecting to receive the goods or the service, whereas the supplier is the one who's more likely to want to rely on this clause and might want different things, different consequences put in. But I've just listed there a few of the things one would want to think about, which will be bespoke to your business, your organization, as to what actually do you want to happen if the worst comes to the worst. And you know, if you want some sort of provision that relieves you from an obligation just because it's become less economically sensible for you to carry on with this contract, well, you need to put it in, because again, I mean, Martin and I, we advise some educational institutions around accommodation contracts where their obligation under the contract was just to pay money to the other party. The fact that they had no students providing them with income to enable them to pay the other party was kind of tough luck, and these clauses often didn't assist them. So there tended to be a commercial solution, as with most of these things. Particularly, I think about where the losses lie, because if the clause is silent, some people think courts may try and apply some of the Law Reform Frustrated Contracts Act doctrines to this, may try and sort of work it in. I'm not convinced by that. I think you've got to provide actually for what you want. So unless there's going to be a total failure of consideration where you may be able to get restitution of money paid, you just want to think through and negotiate for each type of contract what the best result would be in the sorts of circumstances you are thinking about. Now, if we go on to the next slide, after I've talked about this a little bit, we're going to have a poll. So I'm going to see what you say. So this is a clause based in an actual case. Some of you may know the case when I relate the facts. But let's see what the clause says. This was where one party A, sold DVDs and the like. Party B was the logistics and warehouse company which stored all the product, dealt with it, sent it out, dealt with returns, did the whole thing, and they had various contractual obligations. There were riots, and during the course of these riots, some rioters broke in to this facility, kicked down the door, wandered around, nicked a couple of things, chucked a couple of petrol bombs and left. The net result of this, bearing in mind the fire systems they had or didn't have, was that the whole warehouse completely destroyed by fire and destroyed millions and millions of pounds worth of goods. There was this clause in the contract: neither party shall be liable for its failure or delay in performing any of its obligations hereunder, if such failure or delay is caused by circumstances beyond the reasonable control of the party affected, including but not limited to industrial action, fire, flood, wars, armed conflicts, terrorist act, riot, civil commotion, malicious damage, explosion, unavailability of fuel, pandemic, they had that, or governmental or other regulatory action. So I'm going to ask Kate to launch the poll now, which is basically for the warehouse logistics company, in these circumstances where the fire has writers have come in and the fire has destroyed the place, can they rely on this clause to get them out of a hole or help get them out of a hole? I'm seeing the poll now where practically half you have answered. 251 people on the call. So if we get up to close to 200, since we're short of time, I will close the poll. Give you 5, 4, 3, 2, 1. Right. Anyone who's not responded, you can finish now. So if we can share the results, please. There we are. So 58% think they could rely on the clause. Very good. 42% think no. So relatively evenly split. The more think they could than couldn't. Those in the no camp, you can feel very smug because you're right. They couldn't rely on the clause. And why was that? I mean, it's a bit of an unfair question since we've not really gone into the detail of the case. The court basically said, although the rioting was unforeseeable, absolutely that was an unforeseeable event, the fact that people might break into and cause damage to this facility was foreseeable. There had been break-ins in the past, and there were obligations. The fact that there might be fire, well, there were obligations to have adequate fire control systems and so on provided for in the contract. So even though the wider circumstances in which the particular break-in took place weren't foreseeable, the fact that you could get people coming in and causing damage was perfectly foreseeable, and therefore this didn't come within those descriptions. And they said it wasn't beyond the parties' reasonable control, because in fact this wasn't a sophisticated, determined group of criminals, Mission Impossible style, breaking in a high-tech way. This was a group of probably drunk lads who just wandered in, kicked down the door in about 30 seconds, wandered in and chucked a petrol bomb and left. It wasn't a sophisticated raid. And the court found, in fact, they were in breach of contract. They didn't have adequate fire control systems, which could have contained the fire. They didn't have adequate security. They were in breach of contract. This wasn't beyond their reasonable control. So this was the 2 Entertain and Sony case, if you want to read it. But it's a good example of how these clauses, even when they superficially look like they might help, didn't help at all in that case. Okay, so if we can move then on to the next slide, please. And if you've got a problem, I think that the lesson that comes out of this is just be wary about the effect of force majeure clauses, unless you've really thought about them beforehand and put the thought into the drafting. Be wary about relying on them because there could be unintended consequences. Are there other options? Does insurance help you out? Is there a commercial solution? That is often, in fact, fortunately, the answer. But I think for contract drafters, do think about this. And if there's any one lesson that comes out from talking about sort of boilerplate clauses, is that there isn't really any such thing. These clauses do need to be thought about in if not each contract, each type of contract that you have. You may have groups of contracts, but you need to understand what your desired position is in any one type of contract and try and agree it. And then at least you know if you're departing from that, you can assess the risk. But it's worthwhile having a bit of a think about it, because as pandemic and lockdown showed, force majeure events do happen, and they do completely muck up people's contracts. So it's, you want to provide for a rainy day because the rainy day does from time to time occur. Okay, if you could go on to the next slide, I'm going to talk briefly now about dispute resolution clauses. I'm going to talk about what they might provide in terms of alternatives to court litigation as the way to sort out disputes. I'm going to talk about the clauses that require parties to mediate or go through stages of negotiation. And I'm just going to talk briefly about what contracts might say about time limits for claim and some points to think about there, which always as a disputes lawyer I'm acutely aware of. And we try to educate people like Jayne and Martin around practical consequences of some of these things. So if we go on to the next slide, alternatives to litigation. The two obvious ones you might include in a contract are arbitration as a means for resolving disputes or expert determination. Arbitration is, in crude terms, is private, contractually agreed litigation. it's a form of litigation through not through the court system, but you do have an arbitrator who will decide questions of fact and law and will give a judgment. Can be more expensive than litigation in some circumstances. You've got to pay your arbitrator or arbitrators, but it can be a lot cheaper. It's got a lot of flexibility in the system, and it's particularly good in some sectors where you can get specialist tribunals with proper knowledge of the subject matter that you're talking about. May make life easier. They're supposed to be confidential and generally are. And the key thing, certainly for international contracts, is arbitral awards are much, much easier to enforce abroad than court judgments. And that will, as we've left the EU, that will be even more acute, I'm sure. But arbitral awards are, you could easily enforce an arbitration award in the USA, whereas enforcing a judgment, it can be very difficult depending on what state you go to and so on. So when you're thinking about these clauses, the identity of your counterparty, their jurisdiction, where their assets are, where you would enforce any breach, that may lead into whether you go for arbitration. Expert determination can be good for certain. You wouldn't generally have it for a total contract, but for certain issues within a contract, something specialist around, I don't know, an accounting dispute or a technical dispute as to whether a consignment of chemicals meets a technical requirement in a contract. That sort of stuff can be dealt with by an expert. It's a bit sort of quicker, dirty as a means of dispute resolution, and it's unappealable. So if you get on the wrong end of it, it can be unfortunate. But for the right sort of dispute, that's something worth thinking about. So then those are alternatives to litigation. But if we go on to the next slide, what do you do before you go to litigation? And to my mind, that I'm not sure in my own mind whether I think these sorts of clauses are a good idea or not. These are the sort of clauses that say the parties have got to engage in good faith in some form of dispute resolution process before the button is pushed and everyone goes to court or arbitration. So generally speaking, this would provide for one party serves a dispute notice, then the bottom tier of employees meet with each other, try and thrash it out. If that doesn't work, then the more senior employees goes up to board level. Then there may be a requirement for formal mediation or some other form of alternative distribution, and then you go to court. Are these clauses effective? Well, if you don't want anyone to go to court until they have done this, you have to draft these properly to make sure this is a condition precedent before anyone can go to court. If you don't, you just say the parties have got to do this, but you could go to litigation anyway. Then if a party doesn't do this and breaches it, well, what loss or damage has been caused? All that is a kind of contractual reminder that it would be a good idea to try and sort it out before going to litigation, which would be good advice in any case. But it can be sensible to actually make it a condition precedent before the button is pressed. And for certain types of contract, particularly contracts which are going to last for a number of years, which are ongoing provision of services or whatever, I think generally it is a good idea to do this. To make them work, you've got to be clear about the time limits. If these are open-ended with no time limit, they're probably not enforceable. But if it is, serve a dispute notice, then the first tier of employees must meet within 4 weeks. And if that doesn't work, then the more senior employees must meet within another 4 weeks. And then there must be mediation. And then you've got to put in precision, which is the parties will agree the process. And if they don't, then the identity of the mediator will be determined by X, Y, or Z. And these rules will be followed. So all that, it kind of forces parties to the table. It's still a voluntary process. You don't have to agree anything. You can pay lip service and turn up, but at least it gets people thinking about and talking about trying to resolve a dispute without going to court, which has always got to be a good idea. So they can be effective. So yeah, clarity around the sort of machinery and that sort of stuff. When you're drafting them, what do you want to think about? Well, think carefully about who the people are who it is provided should negotiate. You've got to have people who have sufficient familiarity with the dispute, but also have sufficient authority to resolve it or hold sway within their organization. So it may not just be the people on the ground, because they may not have authority to do anything about it, but equally it may be the directors at the top may be too remote to have much of a say. So this will be sort of bespoke to your particular contract. As I say, be clear about the timetable involved, be clear about the scope of any dispute resolution mechanism. So those sorts of issues, and this leads on to my last slide and links into it actually. Time limits for claims, and I've put in the sort of clause that you might find. It's a bit of an extreme one. The purchaser may only bring a claim for breach of warranty if such claim is issued and served on the seller within 12 months of completion. Well, nice and clear. It's enforceable. If you don't issue and serve your claim within that time limit, you're contractually barred from bringing a claim. From a dispute resolutions lawyer's point of view, this sets off so many warning bells. To not only to issue but to serve a claim is quite an onerous thing, and there's all sorts of rules if you leave it till the last minute about service and how people can fall foul of that. So the requirement to serve within 12 months to avoid any problems. In fact, you'd want to be issuing and serving several weeks before that. So in fact, you've got in effect less than 12 months in reality to get your claim ready for issue, even if you're just issuing a protective claim form. That takes a bit of time, so that reduces the time limit in practice. To issue and serve within 12 months, you have to really be kicking on and preparing things after 10 months. Is that enough time? And if you have one of these dispute resolution clauses that are a condition precedent to litigating, and you have to get all that in before you then issue and serve a claim, that would just mean you have to start the dispute resolution process within 3 or 4 months of the contract being entered into, which may be way, way too early. What you might normally have, and which would be sensible, even if you are going to have a time limit, is that you have to serve notice in sufficient detail of a potential claim within 12 months, say, and then you may have another period of time within which to actually bring proceedings, and that at least is more doable. But be very, very wary about anything which requires you to actually issue a claim, and certainly to serve a claim within a particular period of time, because and speak to a disputes lawyer, because there can be all sorts of practical questions there. So that's again one of the sort of boilerplatey type clauses that people don't always think about, but again, a little bit of thought, and it should be easy enough to get something that works for your contract while shortening the limitation period and making sure people get on with claims. So sorry, I've slightly overrun by a couple of minutes from my bit. Apologies, but that very briefly was force majeure and dispute resolution clauses. So any questions arising from that, we're happy to answer. Martin, have we had anything in yet?
So Simon, just before handing over to James, really interesting question that's come in around different arbitration forums, and whether you, Simon, have got any recommendations on the particular forums that are available, such as Central and ICC.
I don't have a strong view. I don't do enough international arbitration to really have much of a view. I mean, I've done arbitrations of various sorts. Some of them have not been, subject to any particular rules. It's just been a barrister who's been appointed or been forced on the parties if they couldn't agree, and then they set the rules. In terms of the pros and cons, what we'll probably do is get Mark Davison, who's our head of international arbitration, to see if we've got any ready reckoners or little tips which we can send to you. So sorry, I can't help on that.
Thank you. And so one final quick one is just a quick question about the clause that you mentioned earlier. Would a clause like this fully prohibit a claim? And is the court's jurisdiction removed?
If we are talking about, are we talking about a tiered dispute resolution clause, or are we talking then about the bring a claim within the time limit? Well, in either case, if they're drafted tightly, those can be effective conditions precedent. So if you have not followed the relevant step, if you have not served notice in time or issued the claim, or if you have not gone through the negotiation procedure, and then you go to court, the court has got the power to stay that and force the parties to go back. If there's a time limit you've missed, and this is where the real danger lies, if you've gone to litigation without completing those steps, the other party raises the point, but in the meantime your limitation period has passed, you could be left without any kind of remedy. So yes, they can be effective as conditions precedent. If they're not a condition precedent, those sorts of clauses, I mean, they could be in there, but so what? What's the loss and damage caused if someone breaches it? Is always the question. A lot of people often think, well, we've got it. It's in our contract. It's important. Yeah, okay. So what? I breach it. Well, what harm has that done to you? So it's a slightly meaningless clause. It may be a breach of contract, but it's a slightly irrelevant breach of contract. But yeah, they can be effective to actually prevent you from starting proceedings and cause all sorts of problems. So that's why you've got to be careful if you do want something to be an actual condition precedent before you take the next step and start litigation. You want to draft it clearly, and you want to understand that that is the position, because that's an area where people can trip up.
Thank you.
Okay, so I will now pick up talking around termination clauses. Again, one of those clauses that is in most contracts and sometimes isn't given the time and thought that that should be given to it. So in a nutshell, the purpose of a termination clause is to set out expressly how the contract will end, and fundamentally to ensure that the parties don't have to rely on common law rights to bring the contract to an end. So, for example, trying to establish a repudiatory breach. And termination clauses really divide down into two categories. So you have your sort of termination for convenience or expiry at the end of a fixed term. And then you have your early termination triggers. And those are usually related to either fault or broadly a change in a party's circumstances. And it's that latter category of termination events that I want to focus on now. So your early termination trigger events. And I've set out on this slide very briefly some typical ones that we see and typical ones that we are asked to consider or include. So typical ones that you would see would be breach, termination for insolvency, termination for a change of control. Interestingly, things that we are asked to consider both in drafting and in the context of looking at contracts that have been entered into are the contract pricing is no longer viable. And indeed, we had quite a bit of that at the start of the pandemic. People asking, well, does that allow us to terminate? And also considerations around reputational risk if there's a change in the circumstances of the counterparty. So I now would like to just unpick those in a little bit more detail. So Kate, if you could move to the next slide, please. So what I've done here is try to summarise some of the key considerations for you. Turning now first to termination for breach and this concept of material breach. And rather like as Simon observed on force majeure, there is no set legal definition of what a material breach is. The courts have generally held that a material breach is a breach that is substantial and serious. It doesn't need to go as far as being a repudiatory breach, but equally small, trivial breaches won't be considered material. There have been cases where a series of minor breaches, when taken together, the impact of those have been held to be material breaches. But it's interesting that we get asked quite a lot, well, can we define what a material breach is in the contract? And my general advice is, no, let's not do that, because it's sort of a bit of a case of sure as eggs is eggs. When you want to rely on it, it's the one thing that doesn't fall within your definition that is the thing you want to rely on. We do sometimes use the sort of non-exhaustive list as examples of things that would be treated as material breach. But I do think it's important that any direction of travel on in a contract on that basis is on a non-exhaustive, non-exclusive basis. As well as material breaches, you need to think about a series of minor breaches. So a breach in and of itself that won't be problematic, but when there's lots of them are going to be hugely irritating, and whether you need a termination trigger event for that. And you also need to consider, what about those breaches that you cannot remedy? And an obvious example of that would be a breach of confidentiality, for example, or a breach of bribery and corruption obligations, anti-bribery and corruption obligations, I should say. So in all of those things, you need to think about a cure period, and you need to think, obviously, with a breach that can't be remedied, a cure period's pretty pointless. But in the context of material breaches, what's the correct cure period? And I think thinking about that in the context of the actual transaction and the relationship and the degree of dependence between the parties is quite important. Because we will see people say, well, actually, it must be, the cure period of 14 days and then it's immediate termination. But then when you unpick it, you find, well, actually, it will take you 3 months to re-procure goods and services. So maybe 14 days is a bit of a pointless number and an arbitrary number to include. So I would say, think about the cure period in the context of the transaction. I think another important point to consider is the interaction of breach provisions with any service level agreement that you have sitting within the relationship. Because a good service level agreement will set out the service levels, but it will also set out the escalation mechanism as to how bad a breach becomes before termination is triggered. And I think it's important that the breach provisions talk to the service level agreement and the escalation mechanism in the service level agreement, and they don't cut across one another and contradict one another. Moving to the next category, which is insolvency and financial distress. And I dare say that all of you are familiar with those standard sort of immediate termination for an insolvency event. The one point I wanted to draw out here was the impact of the Corporate Insolvency and Governance Act, which came into force last year. The impact of that act in the context of a supply of goods and services relationship is that once your counterparty enters into a formal insolvency process, you cannot rely on those formal insolvency trigger events to terminate unless your counterparty agrees or you get a court order. And that is why you will be starting to see more language in contracts around a right to terminate if your counterparty ceases or threatens to cease to carry on business, or if there is a significant financial deterioration of their position. So the point here is ensuring that you have that language in your trigger events, but equally that language is only useful if you actually trigger your termination prior to formal insolvency. So you need that language coupled with very good credit control mechanisms, actually. Another point is around change of control. So this is the ability to terminate if your counterparty fundamentally changes ownership. Well, that's only helpful if you're notified of the change of control rather than having to trawl through the press to find out that your counterparty's changed ownership. So that is a point to build into the clause. I think there is also a question about how you define your change of control and whether it does actually mean any change of control, or whether the real worry area for your business is around, for example, your competitor being your counterparty being acquired by a competitor, or your counterparty falling into the hands of a business where you doing business with them will cause a reputational issue for you. And I would say that drilling down as to what the real worry is around a change of control helps significantly when you are actually negotiating that type of clause. So those are the typical considerations we have. And I mentioned earlier the issue about a contract becoming unprofitable or unviable. And we will get people saying, please, can you put in a termination clause that if it becomes unprofitable, then we can terminate? And you sort of say, well, actually, that's going to be pretty difficult to negotiate. And actually, unless you're prepared to operate on open book, it is also quite meaningless. So what I would say is what we do see, though, is termination trigger events which are linked to a reduction in demand, so below a certain volume threshold. But equally, you can also cut that type of issue in different ways through the contract. So you can deal with them through changes of pricing on a change control order. You can deal with it potentially through a loss of exclusivity if volumes don't reach a certain threshold. So I think if you people within your business are talking to you about the viability of a contract and the profitability of it, don't just think about that in the context of being able to terminate. Think about it in terms of other mechanisms in the contract that you might be able to use to give yourselves protection. So we'll now move to consequences of termination. And again, this can be a little bit of a neglected area in contracts and viewed as boilerplate. So I've jotted down here a few of the considerations that we typically try and drill down with clients on. So the first is, if you've provided your supplier with free issue materials or tooling, we would assume you would want that back, and you need to deal with the mechanisms for getting the materials and tooling back. You need to think about things like, what if tooling comes back damaged? So issues around that. Equally, if your supplier has stocked up on specific materials or bought tooling specifically to service the contract, might you actually need to bring those stocks in-house or have them transferred to your replacement supplier? So again, you need to think about that type of issue in your consequences of termination clause. Likewise, IP licensing. Whether you have licensed your supplier, does that license automatically come to an end? Whether your supplier has developed IP for you, what is going to be the position with that? And I think the equivalent thought process needs to happen with respect to data and any data that has been generated by a supplier during the course of performing their obligations. Termination payments is quite a common issue that we end up having to discuss and negotiate on early termination, because quite often a supplier will amortize their investment costs through the price over an anticipated period of contract duration and volume. Where we tend to land up with that is the termination payments don't apply if the person who is due the payment has caused the termination. So, for example, why should a supplier be compensated for their costs if they've been in breach and triggered the termination? But that is an issue for you to consider and think about. Equally, when you're dealing with things like services outsourcings, there are likely to be TUPE issues that you need to address. And equally, there might be staffing issues in terms of redundancies and so on. So again, that's something else that needs to be thought through. Importantly, if a contract coming to an end is likely to result in you needing to migrate to an alternative supplier, or indeed bring back in-house, the other thought process you need to go through is what level of cooperation you need from your supplier in order to achieve an effective and efficient migration. And that is where the consequences of termination clauses might link into a formal exit plan that sets out who is going to do what and the extent to which you will pay your outgoing supplier for their cooperation and support. And then finally, on accrued rights, I mean, this is the typical, the fact that termination of the contract doesn't extinguish accrued rights, and equally termination of the contract doesn't bring to an end obligations which it is reasonable should consider it continue in full force and effect. And again, obvious clauses around that might well be confidentiality, and it might be the limitations of liability clauses and the dispute resolution clauses and so on. So that's a very quick canter through consequences of termination. And then I will finally just round up by saying a few words on entire agreement clauses. Oh, actually, I won't. I'm getting ahead of myself. A very quick point on exercising termination rights. If you are exercising an early termination right, make sure you very carefully assess the basis for the termination, and you don't delay in exercising your rights, and you follow the correct notice procedures in the contract. And the reason that I make this point is that Simon and I, and Martin indeed, there are have all come across absolutely loads of cases where the business has come unstuck because they've not followed the correct procedures, they've not done the correct assessment. So I would emphasize the importance of this, and I would emphasize the importance of your commercial colleagues, your operational colleagues, not firing off termination notices without actually proper sort of consideration with the in-house legal team. So that was all I wanted to say on that. And now I'm rounding up on entire agreement clauses. A very quick note about this. Again, these tend to sit towards the back of the document. They can be neglected clauses. But a few points. The purpose of these is fundamentally to say that the agreement is the entire agreement, and to avoid parties trying to bring into evidence or introduce other documents and argue that they are part of the agreement. They often incorporate non-reliance wording. The purpose of that is to be clear that neither of you have relied on anything outside of the document in entering into the contract. So to try and avoid liability for misrepresentation. I mean, and obviously you can't exclude liability for fraudulent misrep. So if you like, an entire agreement clause is actually a restriction of remedies. It is a form of limitation clause, although quite often it sits aside of your limitation of liability clause. So it's an important point to think about it in that context. From a practical perspective, what I would say is, if you're a customer and you have appointed a contractor on the basis of their tender or proposal, you ought to be thinking whether there are elements of that tender or proposal that you have relied on that ought to be brought into the contract. Similarly, if you are a supplier, there may be information in the RFQ that you have relied on to calculate your price. And an obvious example there might be volumes. So again, I think exploring the entire agreement clause in the context of what led up to the contractual negotiations can be quite helpful to make sure that you don't trip yourself up, if you like, by sort of ignoring and including a bog standard clause. That brings me to the end of what I wanted to say. So I think now, Martin, I'm handing over to you as question master.
Thank you very much, Jayne. So we've had a few questions in the Q&A box. And first couple of questions, if I may, I will bunch together for Simon. And Simon, if you could firstly talk a little bit about the how the statute of limitations fits in with a contract term which enforces a limitation period, please. And then also, can you finish up your response by talking a little bit about what is meant by act of God in force majeure clauses, please?
Okay. Well, the first one, you're saying if you've put in a contract, effectively a contractual limitation period, you won't have a claim unless you bring it within a year or 2 years or whatever your contract says. But underpinning that, you've got 6 years for breach of contract claim under the Limitation Act. Is the contractual limitation effective? Yes, it is. If the parties agree, it's a term of the bargain between them that you will only be able to get a remedy under this contract for breach of contract if you bring it within 2 years. The courts will enforce the parties' bargains. That's part of what they're there for. So the fact that without that clause you would have had another 4 years is tough. Often you've got to be careful when you draft these things that if you're excluding a claim for breach of contract, you'll find litigation lawyers will be desperately scrabbling around to try and find some other cause of action that isn't a contractual claim. So if you want to exclude these, you want to draft these widely enough that they include all claims in relation to the entry into formation, terms of the contract, etc. If you just say any claim for breach of contract must be brought within 2 years, That doesn't stop me bringing a claim for misrepresentation, unless you've got an entire agreement clause which has excluded it, as Jayne has talked about, or a claim for negligence, or a claim for some other weird and wonderful thing. But yes, they can be perfectly effective, and the courts will enforce the party's bargain. So that's partly what they're there for. Act of God in a force majeure clause. Without looking it up, I don't really know. My recollection is that act of God is a phrase that isn't generally sort of judicially defined or looked at. It isn't, particularly in the context of force majeure clauses, certainly when I've sort of researched them over the last year or so. I think it does appear in some cases, probably in shipping and in some sort of defences to negligence claims where the courts have looked at it. And broadly speaking, I think it's a natural event, unexpected, beyond the party's control, like, an avalanche or an unexpected flood or whatever. Those sorts of things, I imagine, could be what might be an act of God in, South Manchester. If I get hit by an avalanche, that would be an act of God. If I get hit by an avalanche season in Chamonix or whatever, then it's that's probably just something to be expected and dealt with. But so I don't think it's a phrase that has a particular meaning. It might be one of those ones you know it if you see it, but unless you're sort of fairly clear what you mean by it, there's always scope for doubt. So it's as well to have a as long and broad a list as possible. Acts beyond your reasonable control, including boom, 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 include act of God, but it's not necessarily wording you would want to sort of run to trial on necessarily. But that's all I can say, I'm afraid.
Thank you, Simon. And next question for Jayne, please. It's around, and I think it's really a question about constructing, either constructing or reviewing FM clauses. And so Nick mentions he's not been required so far to draft a force majeure clause, but he's asking for tips as to whether there are any pink elephants to look out for when reviewing force majeure clauses from other parties. And I guess also the question extends to how do you construct a well-crafted force majeure clause, Jayne?
Yeah, I mean, I think that's an interesting question because, of course, what you look out for depends which side of the fence you're sitting on, and where. So, if, for example, you're the customer and your supplier, and therefore most of the obligations are on your supplier, then the reality is your supplier is the one who's most likely is at more risk of force majeure than you, and therefore what you would be wanting to do is narrow down, for a start, the list of force majeure events. So, for example, personally, if I'm acting for a customer contracting with a supplier, I don't like the language of anything outside of somebody's reasonable control, including but not limited to, because I sort of think, well, actually, there's a huge amount of things that can be outside of your reasonable control. I also, in that circumstance, look for language around strikes and labour disputes, because my argument would be, well, actually, you're in control of your labour. If it's logistics, I look for, and there's logistics involved, I look for anything that talks about sort of transportation delays, because, again, I would say, no, that is within your control. So I will look at the force majeure clause depending on which side of the fence I'm sitting. If I'm acting for the supplier, of course, I want everything in the kitchen sink in my force majeure clause. So it depends which side you're approaching it from, and it involves sort of thinking about, well, actually, what is the nature of the supply? And then I think it goes back to a lot of the points that Simon was making about, and what actually is the consequence, and is it a delay, a hindrance, is it an absolute prevention, and then what should happen? I mean, quite typically, a sort of just immediate termination isn't actually very helpful to anybody, again, as Simon alluded to. So you might well look to be including things that are almost an escalation mechanism, and you may say, well, actually, you can only rely on your force majeure clause if you've got in place a good business continuity plan and you have followed that business continuity plan. So that there's quite a lot of ingredients to a good clause, but yeah, you sort of approach it from who you're representing and the nature of the transaction.
Thank you very much, Jayne.
Okay.
So I think we've probably got time for a couple more quick questions. One relates to, first of all, I'll quickly deal with the question around financial deterioration. Just really to say that normally this is defined by reference to one of the ratings agencies. You see it particularly, don't you, in large-scale government contracts? So burned by previous contract failures of suppliers. Government contracts tend to include very detailed provisions around the financial viability of their counterparties, and often the financial solvency is defined by reference to ratings. For example, Moody's. So the final question then for Simon is from, and it's around, I think, again, another really interesting question around limitation periods. And so in the circumstances where a product is sold business to business with a 12-month warranty, but the buyer cannily insists that the contract is executed as a deed, with the consequence being that there's a 12-year period for bringing claims. Can the seller then rebut any claims related to the failure of that product or goods post the 12-month warranty period, Simon?
Generally, that wouldn't be an absolute defence. I mean, it all depends on the drafting and what has been agreed. The mere fact, though, as a matter of principle, that for a period of 12 months you warrant a certain level of performance, unless you have also thereby effectively excluded any other kind of right, doesn't in itself override your duties under all the various Sale of Goods Act and Supply of Goods and Services Act and whatever sets of regulations apply these days, which I'm afraid I don't know. So yeah, and you often think about this in a personal context when you're sort of buying something from, buy a washing machine from John Lewis and, oh, do you want the extended warranty? Well, partly I always think as a lawyer, well, you get an automatic 12-month warranty, but after that, if it breaks off after 12 months and a day with modern, decent, high-end consumer white goods, I'd still say that there might well be a breach of contract claim against the seller for selling me duff goods, because you don't expect certain things to collapse just after a year, whether it's in or out of warranty or not. It may still be a breach of some other contract or legislation. So it kind of depends. The particular item being or service being supplied, it particularly depends on the drafting, and then you do get into the sort of knotty questions of how the different regulations apply, if it's business to business, if it's standard terms of conditions, are exclusions fair and effective, all that sort of stuff, which I'm not going to attempt to get into now. But broadly, to the mere fact you've got a contractual warranty period in which certain consequences flow if the contractual term is breached, does not in and of itself mean that you lose other wider contractual rights.
Great, thank you very much, Simon, and thanks again, everyone, for joining us this morning. We really hope you've enjoyed the session, and thank you for the feedback that's already started to come in via the Q&A. Please do give us any feedback that you are able to do, and thank you once again for joining us this morning.
Thanks, Martin. Thank you, everybody.
Thank you, everyone.